Good afternoon to everyone on the line, and welcome to SNC's webinar on M&A practice in a changing environment, lessons learned from the COVID-19 outbreak. We are delighted to be able to share with you our experience on the impact of the COVID-19 crisis on M&A transactions. Before we start, let me introduce the partners on today's panel. Richard Pollack and Vanessa Blackmore, based in London. Richard is also the managing partner of our London office. Konstantin Technau, who's based in Frankfurt. Garth Bray, who will be based in Paris as from this summer. And myself, Olivier de Vilmorin. I'm based in Paris, and I'm also running the European M&A practice at Sullivan & Cromwell. We were involved in a number of large transactions which signed and were announced before the COVID-19 outbreak. Some were renegotiated and closed since then, while some others fell apart. The purpose of this webinar is not to go through each of these transactions, but to pick a few, mainly the Essilor GrandVision transaction, which just closed recently, and the Tiffany LVMH transaction, which closed a while ago, and discuss what can be learned from those deals. Also, there have been some court decisions in the US and in the UK in connection with the underlying issues raised by the COVID-19 crisis, which will be addressed by Richard, Garth, and Vanessa, and which may have an impact on the way other courts approach things. Before we get into the discussion, though, a quick note on the Q&A. The Q&A function has been enabled, so feel free to send any questions you have during the webinar. We have allocated some time at the end of this session to go through some of these questions, and we have received some in advance already, so thank you very much. As you will see, most of the issues raised on these transactions were around MACs and interim operating covenants. Richard, before talking about the SLX acquisition of GrandVision, can you say a few words about what MACs and interim operating covenants are?
Thank you, Olivier. I'm happy to. A MAC out is a provision that says if the target has experienced a material adverse change from some agreed date, that's usually the date of last audited financial statements around the time the transaction was signed up, but it's not always that date. If that material adverse change occurs, then the buyer doesn't have to close. MAC clauses have evolved in a way that, in general, they tend to allocate company-specific risk to the seller and market or general risks to the buyer. A typical MAC clause starts out by saying, in very general terms, a MAC means a material adverse change in the target's business, but then it goes on to say the following things don't count as MACs, even if they've led to a material adverse change in the target's business. That list of exceptions has grown pretty long over the years and carves out things generally affecting the market, like, for example, the global financial crisis in 2008 and 2009, wars, natural disasters, and in many cases, the clauses expressly carve out pandemics. MAC outs are pretty common in US transactions. They're somewhat less common in European transactions, though. Interestingly, though, MAC outs are notoriously hard for buyers to use. Obviously, not all MACs get litigated. Sometimes the parties actually agree that a MAC has occurred. But in the cases that have been litigated, buyers don't have a successful track record of winning the cases. In fact, in Delaware, for all of history, there has been exactly one case where a Delaware court has actually found that a MAC occurred. So for all of the debate about MACs, they really don't afford buyers a lot of protection in reality. The other thing we're going to talk about today is interim operating covenants. Interim operating covenants are a series of commitments by the target as to how it will operate its business between signing and closing. Typically, the interim operating covenants start out with a very general provision saying the target will operate in the ordinary course consistent with past practice. They then usually go on to have a number of specific undertakings covering things like the target maintaining its relationships with its landlords, its suppliers, customers, and regulators, maintaining CapEx, not making commitments outside of its agreed budget, etc. The list can be very long. Related to the interim operating covenants, there's typically a condition to the buyer's obligation to close, saying that the buyer doesn't have to close if the target has breached its interim operating covenants in a material respect. So with that, why don't I give a little background on EssilorLuxottica's acquisition of GrandVision. SLX did not have a MAC condition in the acquisition. So the main issue between SLX and GrandVision related to the interim operating covenants that Grand Vision agreed to abide by in connection with the acquisition. As is usually the case, there was both a covenant that Grand Vision would continue to operate its business in the ordinary course consistent with past practice, and a separate list of specific covenants covering a wide range of topics. So the pandemic came along, and Grand Vision took a series of actions like it closed stores, it cut its capex dramatically, it furloughed employees, and it sent out letters to all of its landlords refusing to pay its rent. The arguments in the litigation were along the following lines. Grand Vision took the view that because there was no MAC out, the risk of the pandemic was shifted to SLX. SLX took the view that irrespective of there not being a MAC out, Grand Vision was required to live with its ordinary course and related covenants, and that by taking various actions in response to the pandemic, it had breached those obligations. On that, Grand Vision argued that ordinary course doesn't just mean how it actually operated its business historically, but how it would ordinarily respond to massive disruptions in its markets, like the disruption caused by the pandemic. It also pointed to what other companies in the industry have done, and it argued that because Grand Vision was arguably doing the same things as its competitors, that's how ordinary course should be measured. In addition to the general covenant, as I mentioned, there were also a number of specific covenants that were implicated. As a few examples, there were covenants about not reducing capex, not losing customers, maintaining its relationships with landlords, etc. So the case was decided in late June, and SLX won. The arbitrators found that Grand Vision had breached its interim operating covenants and held that the condition to closing wasn't satisfied, and SLX was entitled to terminate the acquisition. SLX actually elected to go forward anyway, and the deal closed on July 1st.
Thank you, Richard. Thank you, and this is very, very interesting. Before we move to various cases, maybe we can talk about the Tiffany LVMH transaction. Most of you already know this deal, and I don't think we need to go through the background of the transaction. To renegotiate, because that was the purpose, in addition to the letter from the French Ministry of Foreign Affairs, LVMH tried to argue that the crisis constituted a MAC and that Tiffany had not complied with its interim operating covenants. Interestingly, the MAC provided for exclusions such as changes generally affecting the industry in which Tiffany operates, outbreak and escalation of hostilities such as the Hong Kong protest at that time and the yellow vest movement, except of course if it has a materially disproportionate effect on Tiffany. There was no COVID-19 pandemic exclusion, and LVMH made the argument that therefore the COVID-19 should be considered as a MAC. Also, LVMH considered that the crisis had a disproportionate effect on Tiffany. What was put forward by Tiffany is that there was no need for a COVID-19 exclusion, and it was captured by the conditions generally affecting the industries in which Tiffany and LVMH operate. And regarding the disproportionate effect, it was responded by indicating that Tiffany experienced only a single quarter of losses before returning to profitability. And in fact, the fourth quarter of 2020 was higher than the 2019 one. So therefore, for Tiffany, there was no long-term effect of the crisis. So that's on the MAC. On the interim operating covenant, LVMH made the argument that Tiffany had not complied with a number of them. Interestingly, and we will discuss later the importance of this provision, the ordinary course clause did not refer to past practice. Tiffany was therefore able to make the argument that ordinary course doesn't mean how it actually operated the business in the past, but how it should ordinarily respond to the massive crisis caused by the pandemic. In fact, Tiffany made all its operating decisions after having analyzed what had been done by competitors, including LVMH, regarding store closures, safety measures, and others. And also, Tiffany made sure to comply with all the specific covenants provided for in the combination agreement. After that, there was, as everybody knows, an amendment to the merger agreement, and the parties reached an agreement on October 28, which provided for a specific exclusion from the MAC for COVID-19 events, including from the disproportionate effect exception. So even if the COVID-19 crisis had a disproportionate effect on the party, it would not be considered as a MAC. And the interim operating covenants included specific exceptions relating to the COVID-19 measures. Richard, in light of those elements, do you want to speak about the AB Stables case, and then afterwards Garth will speak about the Kohlberg case?
Yep, absolutely. So I talked about SLX earlier. There was a very similar case decided in Delaware in the fall. In that case, which was called AB Stable versus MAPS Hotels, the Delaware court held, and I'm going to quote, "If acting in the ordinary course of business meant doing what was ordinary during the pandemic, then seller would not have breached the ordinary course covenant. But under extant Delaware law, the ordinary course covenant required seller to maintain the normal and ordinary routine of the business," end of quote. So in other words, in a typical ordinary course covenant that is used in many, many agreements, you don't get to do out of the ordinary things because there are extraordinary circumstances, and you don't get to look at what your competitors are doing, only how the target itself normally conducted its business. Just while I'm on it, I should mention that in the AB Stable case, there was also a MAC condition. The Delaware court held that the pandemic fit within one and possibly up to three of the exceptions under the definition of a MAC used in the acquisition agreement, so the MAC was not available to the buyer in that case. Because the pandemic fit within an exception, the court never actually had to reach a conclusion as to whether the pandemic would have constituted a MAC under Delaware law if that exception had not applied, which is actually a big question mark none of us know the answer to. You can debate whether the AB Stable case came out in the right place. In fact, in preparing for this presentation today, a number of us got into a heated debate on that exact issue. And in the SLX arbitration decision, one of the three arbitrators dissented from the decision and indicated he would have ruled the other way. So you can see these are difficult cases and tough decisions. But whatever your views, you can see there's a tremendous amount of uncertainty that people will have to navigate going forward as they negotiate new agreements.
Garth, do you want to talk about the Phipps Kohlberg decision?
Sure. Thank you, Olivier. The Snow Phipps Kohlberg case was a Delaware Chancery Court decision of a couple of months ago, relates to a transaction that was done right in the eye of the COVID storm. Kohlberg entered into a purchase agreement to acquire a cake decorating business from another private equity firm, Snow Phipps, in March of 2020. The decision is interesting in a number of respects and worth a read. It covers a lot of the topics that we're addressing. The background is that there had already been one price reduction negotiated by the buyer because the target was already beginning to feel the effects of COVID when the deal was signed. They went ahead and did the deal, but very shortly thereafter, as circumstances in the US were deteriorating, Kohlberg clearly began to change its perspective on the target. It did a number of things in the wake of that sort of change of heart, which ended up working against it with the court. One of the things it did was it went off and prepared its own projections relating to the business without actually consulting with the target. The court ended up deciding that those projections were draconian and difficult to justify. But Kohlberg shared the projections with its lenders, the people that had signed up to the debt commitment letter for the transaction, and requested changes to the financing package as a result of the change in outlook. The lenders rejected that request, but said that they were willing to live with the original terms offered. Kohlberg engaged in a relatively brief search for alternative financing, and when it couldn't come up with any, it notified the target and the seller that the debt financing was unavailable, and therefore it was not going to proceed to close. At which point the seller sued for specific performance. The court sort of works through the various relevant contractual provisions. The buyer said that the pandemic constituted an MAE. The court disagreed, said that the relatively brief and not overly severe dip in the target's performance was not even close to the Delaware standard for an MAE. The buyer argued that the target had breached its interim operating covenants because it drew down on a bank facility and it reduced staff to some extent. But the court found that those covenants were subject to a materiality standard, and the actions taken by the target didn't breach that. There were two particularly interesting elements, I think, from my point of view in the decision, one of which relates to specific performance. The contract had a fairly customary PE mechanism to the effect that specific performance was only available to the seller in the event that the debt condition had been satisfied. And here, for the reasons I just articulated, that debt condition wasn't satisfied. So the buyer's position was, you can get your protection is the break fee, and you're not specific performance. The court disagreed with that on the theory that the buyer's conduct had contributed materially to the failure of the debt condition, and therefore on a sort of an unclean hands prevention doctrine basis, the court said that it was going to disregard the closing condition and allow specific performance. The other thing that comes through that's very interesting in the case is that the buyer's conduct clearly suggested to the court that there had been a change of heart about the transaction and that it wasn't living up to its obligations, its efforts, obligations under the contract. The projections, the way that was managed, the fact that these fairly severe numbers were produced and shared with banks without actually consulting with the target, the relatively brief period of time that the buyer looked for alternative financing before notifying the target that it wasn't going to proceed, and various other elements clearly colored the way the court looked at this. Since we're trying to focus on lessons learned, I think one of the lessons here is that even when circumstances have changed, people need to be very mindful of their efforts, obligations under these contracts, and make sure that they're doing what they can to create a record that shows they lived up to them. Olivier.
Yeah, thank you, Garth. Maybe Vanessa, because we're talking about Delaware, but we've also seen in the UK some interesting case law. Do you want to talk about the WEX ENET High Court judgment?
Yes, thanks, Olivier. And sort of following on and from what Richard, Olivier, and Garth have been saying, there was an English case that came out of the COVID pandemic that's interesting. And I think certainly as far as the UK is concerned, there isn't an awful lot of case law in the UK on MAEs, and certainly in the context of sale and purchase agreements. And certainly not in the context of a pandemic. There's a bit more case law around what an MAE is in terms of financing documents. So this is an unusual case because in the WEX transaction there was an MAE clause in a private M&A deal, and that is not as common as say in the US. The facts were that WEX agreed to buy the shares in two companies, one called ENET and the other called Optal, and their businesses were in the sort of business-to-business payment services sort of sector, and they were focused on the travel industry. It was a condition precedent to closing that since the SPA was entered into, there shouldn't have been an MAE and no event change or whatever that would be reasonably be expected to have an MAE. Now, what this case went on to decide, it didn't actually go to full trial. It was a preliminary hearing on a point of construction around the MAE clause, and it was done on an expedited basis because there was an outside date coming up after which WEX's debt commitment for the acquisition was going to expire. So the clause in question, there was an MAE, a sort of typical US style MAE that said, that put the risk on the sellers that if there was an event change, development, etc., that had a material adverse effect on the business condition, financial or otherwise, or results of operation of the targets. There were two, but the deals were interconditional. That was a reason that you could walk away from the deal. And the court had to consider various elements of the US style MAE definition. And in this case, there was a carve out for pandemics, which basically took the Mac away again. But then there was an exception to the carve out that covered a number of things, including pandemics, which would have allowed WEX to claim a material adverse event if it could show that the pandemic had a disproportionate effect on the business of the targets as compared to other participants in the industries in which the targets operated. And so the case really turned on what this exception to the carve-out meant. It didn't actually, the court, very much like some of the Delaware cases, didn't actually have to decide at the end of the day in this hearing whether or not there was an MAE. What was clear from the case was that the purchaser, WEX, actually had the burden of proving that this exception to the carve-out applied. So it had to show that the pandemic had a disproportionate effect on the target business as compared to other participants in the industry. So the main question was, well, what was this industry? And I think what comes out of it is that an industry is distinct from markets or sectors within the industry. And the relevant industry here was the B2B payments industry, and not, as the sellers had argued, the travel payments industry. And so what the general principles coming out of this case are, I think, quite interesting. The court basically looked at the drafting and construed it and said that there was nothing in the drafting to construe a narrow interpretation of what the targets industry was. And this finding was important in terms of supporting WEX's claim to go on to say that the targets had been disproportionately affected because the pandemic had a specific effect on the travel industry as compared to the rest of the B2B payment industry. And what's also interesting is that in this case, the court actually considered a number of MAC clauses and obviously noted that most of English law precedent was in finance documents rather than SPAs. But the sellers in the case made reference to Delaware case law, and the English court said that whilst that wasn't binding or formally persuasive, it would be unwise to ignore the thinking from the leading forum for consideration of these types of clauses. So the court actually had regard to what Delaware had to say about MAE clauses. The court also found that there was no special principle that applied to MAE clauses as a matter of English law, and that you didn't have to construe it strictly against the party trying to invoke it. And so it came down to a question of actually, how do you actually construe the clause? And so, I think what we take away from this case is that, if one of these clauses comes before the court again, it would be considered on the usual principles of contractual construction. As I said earlier, it wasn't ever decided whether this was or wasn't an MAE. It just decided that it was likely to come within the exception to the exception. And what actually happened was that the case settled and the acquisition actually went on to complete, but at a much reduced consideration.
Thank you, Vanessa. And indeed, we see that in light of the number of cases in Delaware, not only the English court, but a lot of European courts will take them into account in in reviewing the arguments and in making their decisions. So that's why it's very important to follow how things evolve in Delaware. Maybe now we can move to, what we've learned from those transactions and core decisions for future deals. And Konstantin, do you want to start with the interim operating covenants?
Sure, Olivier, happy to do so. So far we discussed real life examples that illustrate the uncertainty about the interpretation of agreements, but in situations where the parties entered into the SPIA prior to the pandemic crisis, i.e. without being able to assess and appropriately address the COVID-related risks and restrictions. However, our topic for the webinar today is lessons learned. So we have to ask ourselves what we could do better from a seller's and from a buyer's perspective to protect the respective parties' interests should a situation like COVID arise again. I will discuss this matter in relation to operating covenants, then Garth Bray will speak about implications for MAC clauses and comparable closing conditions. As Richard explained in the beginning, almost all purchase agreements contain a covenant for the seller or the company to continue to operate the business in its ordinary course until closing and to refrain from certain action that would change the business compared to what was presented to the buyer in the course of the due diligence. Despite these restrictions, a seller will be interested to have flexibility in reacting to unforeseen circumstances in a situation in which it is impossible or inadvisable to continue to operate the business in accordance with past practice. Having said this, here we have to distinguish. First, there may be situations where the target is prohibited to operate its business as it would normally do. Let's look at an example. We have a retail business that is required under applicable law to close its shops due to pandemic restrictions. If it complies with these restrictions, it is impossible for the target to operate in the ordinary course in this regard. But this is the less complex area of disalignment of interest between seller and purchaser. More complicated are deviations from past practice that are not mandated by applicable law, but make economic sense in light of the circumstances. So if we look at the example of the retail business again, all shops are closed. It makes perfect sense for the target to cut the marketing budget rather than continuing to advertise products that it is currently prohibited to sell to his customers. Accordingly, it is at least desirable from a seller's perspective to include a clarification that the target is permitted to deviate from past practice in case the target reacts to unforeseen circumstances in line with industry practice. At least the seller would want to be sure that regardless of whether he continues to be required to close the transaction, i.e. whether it's a closing condition, that he is not subject to indemnity or damage claims resulting from a breach of a covenant if he takes measures purely to save his business. So far the seller's perspective, but what do we recommend in case we represent a buyer? Obviously, every buyer, even in a COVID-like situation, has a legitimate interest to get what he pays for. Ultimately, not only the decision whether or not to buy a business, but also the agreement on the purchase price is based on the state of business as it is presented to the buyer prior to the signing of the SPA. Accordingly, even under unforeseen circumstances, the buyer wants to prevent the seller and the target from deviating at their discretion from their obligations under the operating covenants. This at least forces the seller to solicit the buyer's consent for a covenant waiver, which provides an opportunity for the purchaser to renegotiate the purchase price in case of deviations that have value implications.
Thank you. Vanessa, do you want to talk a little bit about the how do you see things in the UK?
Yeah, so I think just taking the MAC or the MAE first, I think that, actually, as far as the UK is concerned, I think that the WEX case I talked about was actually quite an unusual situation. I think that it is less usual in the UK. We do have MAC clauses, but tend not to be the broad general wording that that is more favoured, say, in the US, and that follows the sort of Delaware precedents. I think it's more likely, if you have a MAC, to have something that is more specific around particular identified risks in connection with the business, and sometimes also, favouring more specific metrics as to how you measure a MAC, as opposed to having a more generic concept of a material adverse change on the financial condition. I think that still holds, actually. I think that whether or not you have a MAC in your M&A transaction still is a question of sort of negotiation and relative bargaining strength. I think, again, in light of things like the pandemic, if there are things that you know about, you have to have very specific drafting, because I think that the courts here would say, if you know about something, that you can't really rely on that to then claim a MAC. So I think what I would say is, a focus very much on precise drafting. The more specific the clause can be, I think the more likely it is that your clause would, if it ever comes to court, would stand up. I think the other point I would make is that, there aren't very many cases in the UK on MAEs and MACs, certainly in the context of private M&A deals. And I think that's because actually people just tend to, and this is borne out by my experience anyway, that, litigation is very, very uncertain. And even if you think you've got a very strong case, that, actually litigation can be quite subjective in terms of, how a judge might, view the relative merits and the behaviours of the parties. And so what we've seen is that when these questions have come up, that parties have tended to take a pragmatic approach and looked to settle rather than going to court, mostly because if you're on the sell side, you want to have your money and move on with your life, rather than be embroiled in litigation, which can actually take a very, very long time. In the WEX case, that was done under an expedited process, under a procedure that is designed to deal with questions of interpretation on a very short timetable, no more than, say, 4 days. But if a case was going to full trial, that could take, months and years, and, that people tend not to want to be hanging around for that long. I think on interim covenants, I think really it's an extension of what Konstantin's been talking about. And the debate is really around, do you have some sort of what is ordinary course of business, or do you have some kind of overriding exception for emergencies and then there's a debate around how you negotiate that. Do you have to consult? Has it got to be for the purpose of minimizing any adverse effect and those sorts of things? And I think Richard touched on this as well, that, certainly when you've got lockbox structures and your pricing is determined by reference to a set of accounts and a set of state of affairs at a previous date, those sorts of interim covenants are very tight, and it puts a lot of stress on those sorts of discussions.
Thank you. No, that's very useful. Thank you, Vanessa. Maybe before we come to and we discuss further again on MAC, Konstantin, in relation to interim covenant, do you think that makes a difference whether the agreement provides for a lockbox structure or purchase price adjustment based on the closing date accounts?
Yes, it makes a difference, but the answer again differs when you look at it from a seller's or from a purchaser's perspective. So you may argue in case of a locked box, the risk of deterioration of the business shifts to the buyer at signing and not at closing. So the buyer should be prepared to bear the risk of unforeseen circumstances. On the other hand, the buyer may argue, in particular, if the risk shifts to him upon signing, that the protection under the operating covenants is even more critical for him. And we see that in lockbox, agreements that follow a lockbox structure, you typically have additional covenants to protect the buyer from certain actions from the sell side. And then finally, in case we have closing date accounts, we have to bear in mind that there are certain covenants that specifically protect the purchaser against manipulation or inadequate results of the determination of the final purchase price. For example, if you have a minimum capex covenant, and I think that was also relevant in a comparable context in the case Richard discussed earlier, if you have a minimum capex covenant, that covenant is meant to protect the purchaser from an artificial inflation of cash resulting from cuts in the capex budget. And given that in case you have closing date accounts, this additional cash would have to be compensated by the buyer at closing. It's very critical, regardless of whether we are in a COVID or outside a COVID situation, that there is some protection for the seller against manipulation or inflation of the purchase price.
Okay, no, that's very good. Thank you, Konstantin. One question from the audience, maybe Richard. Some of these cases suggest that the target company cannot take any action to respond to the COVID without breaching the agreement and the conduct of business covenants. However, if the directors don't take reasonable steps to respond to the COVID, then they're in breach of their fiduciary duties. Have these issues been addressed by the courts and the arbitrators in the various cases?
That's a great question. So the answer is not straight away and not in a clear way. So in SLX, we anticipated that argument, and we put in a lot of our papers covered the idea that the target could have complied with its interim operating covenants and also responded to COVID in a way that allowed them to carry out their fiduciary duties, and they argued the opposite. They argued that they were only doing what they thought was necessary, consistent with their fiduciary duties. But the arbitrators never actually reached that issue. I think they just looked at it as a mess and decided not to address that issue. And in AB Stable, there wasn't anything on fiduciary duties, but there was actually a related point, which is the court there said, had people successfully argued to us that they had to take these actions because they were ordered to. So, for example, you have to close hotels because there's a government order saying the hotels have to close, and that's why they weren't able to comply with the interim operating covenants. We may have come to a different decision, but in that case, the parties never argued that it was a legal requirement to close the hotel. So, in that case, they missed the opportunity. They'd mentioned it once in one of their filings and apparently never pursued the argument. So the court said we might have come to a different answer in that situation if there had been a legal duty to do it, but you never made the argument. So we're going to ignore that possibility.
Olivier, maybe just one additional word based on the Kohlberg case, which doesn't get to the question of the intersection of fiduciary duties and contractual restrictions, but does set precedent that there is some measure of flexibility for companies to react. The actions taken there that were at issue were drawing down on a credit facility, which was unusual and out of the ordinary course of business, but the court looked at that and said, this wasn't done because there was an urgent liquidity crisis. It was done as a precautionary measure to have cash on hand if it was needed. And so it didn't sort of cross a line in terms of materiality. And the court also considered the layoffs that the buyer argued were also outside of the ordinary course. And the court took the position that it was relatively consistent with past practice for the company to staff up and staff down based on the performance of the business, and therefore that didn't cross the line. So at least from a Delaware perspective, based on some of the guidance in these cases, it's not an overly restrictive interpretation of the the company's flexibility to react.
Okay, thank you, Garth. Do you want now to speak a little bit about MACs and MAEs and what we've learned, and how could we address the issues raised, and then we can go for a few questions.
Okay, perfect. Sure, Olivier. Yeah, Vanessa and Richard did a terrific job of sort of laying out the architecture of these things. So maybe I'll kind of skip to the end of the discussion. As people know, there are in a sort of a customary U.S. MAC, there are basically three layers to it. There's the general statement, that certain types of events that have certain level of financial impact on the company can constitute an MAE. Then there's a second layer, which is a series of broad exceptions, which, as Richard said, effectively have the effect of transferring general macro type risk to the buyer. And then the third layer is a set of exceptions to at least some of those exclusions. And Vanessa discussed that in some detail, the sort of disproportionate impact idea. In other words, a pandemic may or may not be an MAE, depending on whether it has a disproportionate impact on the target relative to some defined control group. In terms of lessons learned and drafting changes that we're seeing, there hasn't been a whole lot to the first two layers. As you might expect, virtually every contract that we've seen that's been, there are, with a limited number of exceptions, most contracts since the crisis broke have included some version of a pandemic exception. And so the skirmishing and where you can help make a difference in terms of outcome with the drafting is in the disproportionate impact language, and being careful to make sure that, depending on which side of the table you're on, you're creating the right control group to compare your target to. Coming back to the Kohlberg case, this was actually an issue that was considered by the court because this was a funny sort of business that produced cake decorating ingredients and equipment to be sold to supermarkets, for their own purposes and for their own, their bakeries. And the buyer tried to argue that you should compare that Decopac's performance to the grocery industry generally, because that would have resulted in a picture of, this particular supplier was underperforming relative to groceries as a whole. But similar to the case that Vanessa discussed, the court said that's not right. You've got to look at this on an apples to apples basis and compare these guys to other suppliers who operate in the same way and not to the grocery industry more generally. And so trying to be thoughtful about how you're crafting those comparisons, and what sort of control group you're setting up, whether you introduce size, geography, other specific distinguishing elements in order to help, steer that to the right outcome is an important issue that people are thinking about. But perhaps more fundamentally, people are probably taking away from some of this discussion that an MAE clause doesn't necessarily have the, create the protections for buyers that you might intuitively expect that it would. And I think Vanessa got at this very well too. A way to deal with that is to craft more specific conditions that relate to very particular metrics, whether it's debt levels, whether it's revenue earnings targets holding up, whether it's customer or employee retention, specific metrics that were important to the buyer in thinking about how it valued the business and priced the deal. Again, all of these things come down to negotiating leverage, but where there's a path for the buyer to implement some sort of metric-specific closing protection that really relates to how they view the business and under what circumstances they're willing to complete the deal, may be a much more useful way to spend negotiating capital than than haggling over the traditional sort of U.S. style MAE language.
Yeah. So you think that it would make sense to go for more targeted MACs and covering, specific aspects of the assumptions, specific assets or assumptions of the valuation that made by the purchaser?
I think when you're on the buy side, it's certainly worth considering that, because again, it's a funny conversation to be having about drafting around disproportionate impact so that an exception to an exception gets the buyer the protection that it's looking for is a rather indirect way of getting at what you could otherwise get at by the sorts of provisions that Vanessa was discussing.
And Garth, it's right that we think it would be more likely to be enforced by a court if you were to do it that way, right? It's right now, MACs, we have the one case in Delaware that's ever found a MAC, but those specific things that, are very, the more objective they are, the more likely we think a court would actually find there to be a MAC.
Fully agree, yes.
Or find the condition isn't satisfied.
Yeah.
But one question that we received before is, if MACs don't work, why do people bother to include them? What do you think, Garth?
Well, it's Richard said, it's a clause that's evolved over time. It's a customary clause that people expect to see. Frankly, in some ways, it may be more helpful to the seller than the buyer. But that means the seller is going to want to see a fairly customary provision so that it knows what it's dealing with. I think there are a number of elements to this. Many more cases, I think, are settled than end up being, fully litigated. And so some of this goes to negotiating leverage and posture as people are trying to work out the disputes over whether they have an obligation to close. There's some benefit to including these clauses in that context. I don't know. I mean, Richard, what's your sense of whether you might be better off just saying to clients, look, let's just chuck this. It's not providing the buyer the benefit that it wants, and it's too indirect a way to achieve the protections.
I actually agree with that. I mean, that's why SLX didn't have a MAC in the end, because we were fighting over it, and in the end, we had the conversation about it doesn't really afford you very much protection, so go with that. And I think that's the right answer. I don't think anybody buying a company should take any comfort from the fact that they've negotiated a traditional MAC as opposed to one of the more specific targeted ones along the lines of what you were talking about, where I think there's more likelihood that a court would respect it. I think, I made the comment before that had AB Stable reached the question of whether a MAC had occurred, which it never did, because it found that the pandemic fit into at least, 3 different carve-outs from the definition of the MAC. I think there's a very high probability that they would have found that the pandemic did not constitute a MAC. And if this pandemic doesn't constitute a MAC for a hotel business that had to close, then you kind of question what does, and does anything really fit into that category? Which I think is a fair question in current law. Or what do you think would actually constitute a MAC?
Well,
get a court to fund.
So the one case that you mentioned, Richard, or you referred to that did find a MAC, the Acorn Fresenius case of a couple of years ago, sort of restates the Delaware position that it needs to be, you need to be able to demonstrate a very substantial economic impact, and it needs to be long lasting. And in that case, I believe the numbers were something like a 25% revenue decline, which carried on for 5 consecutive quarters. And so in that particular decision, that was the sort of magnitude of impact that you needed to demonstrate. On the other hand, that was a very unique, that was a unique case, and there was a lot going on there. There were There were it was a pharmaceutical deal. There were regulatory issues. There were data integrity issues. There was a whole host of problems that contributed to the downturn in performance. And so it's certainly not what you think of when you think of an MAE clause. It's not a hurricane that took out a plant. It's not a pandemic. It's not, it was a series of very specific things, which frankly, I think caused the court to question the integrity of the target and the sellers, and therefore to be sympathetic to the buyers.
The way I remember that case is almost rising to the level of actual fraud.
Yes, it was very, really very close to that. Correct.
Yeah. One interesting aspect is I had the discussion recently with a client, and I had the same approach. But I think one of the interests of the MAC is, although you know that there is a fair chance that it will not work out, if there is an event, it gives you the possibility to sit around the table and have a discussion.
Yeah.
If you don't have a MAC and say, in any event, it doesn't work, so why bother? Then you don't even have that, I would say, discussion phase before the litigation, because first, not every deal is litigated, and it's true that the COVID was a particular situation, and it's true that you don't necessarily get a court decision, but it gives you, if the MAC is appropriately drafted, of course, mini-MACs are better than broad standard MACs, but it gives you an argument as a buyer to sit around the table, which has some use in some circumstances.
I agree with that.
Maybe Konstantin, on the interim operating covenants, just before we finish, another question that we got before the session is, what people have been doing differently over the last 12 to 18 months in terms of dealing with those the drafting of those operating covenants, because now we have some views as to the disputes arising from the pandemic.
Well, I mean, what we're seeing right now is that these covenants, as they are being agreed upon during the pandemic, and depending on the view, it's not over, that those measures that are being taken currently to protect the business against the COVID situation are being carved out from covenants quite frequently. I think the punchline is currently that some of the purchasers try, in line with what we discussed before, to extend the application of this carve-out from the operating covenants to comparable situations, and not only COVID-19 explicitly. And this obviously is being, depending on who has the better bargaining power, the outcome may be one way or the other. The other discussion point is whether now, with almost 18 months of experience on how business tend to react and how a particular business has reacted to the COVID crisis, whether the carve-out is effectively limited to those measures that have been taken. So it's again some sort of past practice test, or whether you would also carve out new measures that a business would take in order to respond to the same crisis. I think this is kind of these are the discussion points at this stage.
I would just add, Konstantin, because we had the question before, I think it was from Michelle, who had asked this about fiduciary duties. I haven't seen anyone try in any of the deals I've done to have a general carve out to allow people to take whatever actions they decide are consistent with their fiduciary duties. And if I were on the buy side, I wouldn't accept that because it would be far too vague. So I think the debate is exactly along the lines you outlined, Konstantin. On the one hand, the seller says, well, we have to be able to take COVID-19 actions as an exception, and that can be things specifically related to COVID-19, or in some cases I've seen it be all pandemics defined as COVID-19. And then the pushback is, okay, but it has to be consistent with what you've done over the last 18 months. It can't be beyond that. And that's sort of the back and forth I've seen. I haven't seen anyone try to or succeed in getting something broader in terms of just a carte blanche to do whatever they need to do if they think their fiduciary duties dictate that.
Okay. Thank you, Richard. Thank you, Konstantin. I think that brings us to the end of our webinar. On behalf of the panel, we want to thank you for joining us today. If you have any questions regarding these topics or other topics, please do not hesitate to reach out to any of us or to your other usual SNC contacts. Thank you very much and have a very nice summer.
Thanks, everyone.